time, and we're in the middle of a vote. So, Senator Lee, please.
One of the reasons why some hearings like this can become heated and contentious has to do with the immense authority that the FCC has, and that relates to some of the questions I wanted to ask. Who has lawmaking authority under our constitutional system? Is it a federal agency or is it Congress?
Congress.
So it stems from that, and therefore an agency shouldn't be legislating. That is, an agency shouldn't be prescribing rules of general applicability to the public without authority from Congress. Would you agree with that?
Yes.
And an agency, once granted that authority, should confine its rulemaking authority to that delegated by Congress, correct?
Yes.
Now, what about where there's ambiguity? Should a federal agency that's charged with administering one of these statutes, granting some delegation, should they harness the ambiguity and then use that to parlay it into their rulemaking power to force the hand of Congress?
Well, Senator, I've lived and died by the Chevron doctrine, and the Supreme Court has said that where language of the law is ambiguous, unless what an agency does is arbitrary and capricious, they get deference.
Sure. I get that, but I think you see the point that I'm describing. I certainly agree with your first two answers, and I also understand the Chevron doctrine and what it says and what it does. I do think it's important to contrast the answers that you provided in response to my first two questions, with which I wholeheartedly agree, with other statements that you've made, some of which concern me. One of them that concerns me in particular deals with what I think a pretty good example of the kind of thing that I'm concerned about in administrative law generally, which is the harnessing of statutory ambiguity in the text in order to force the hand of Congress, the very entity that must delegate the rulemaking power in question. Because when that happens, the people's elected lawmakers no longer are in the driver's seat. Now, this particular statement that I want to draw your attention to was one that you made specifically in the context of net neutrality, when asked a question about net neutrality legislation. Here's what you said, quote, "As became clear during the COVID-19 pandemic, broadband is an essential service and it cannot continue without oversight. Therefore, while I would urge swift congressional action, consumers cannot be left unprotected while Congress deliberates." So we've both just agreed that an agency shouldn't exercise rulemaking power absent congressional delegation, authorization to do that very thing. And yet that does seem to be the opposite of what you had just said you would like to do. In other words, you're saying that while Congress deliberates, if Congress doesn't act to your liking, to your satisfaction, the FCC would have to jump in and make up the difference. How can those two things be reconciled?
Yeah,
because if you're trying to force the hand of the agency, of the lawmaking body of the federal government by doing that which only Congress can do, how is that constitutional?
Well, I guess I might have misunderstood you. Obviously, where Congress has said specifically that an agency cannot act, it cannot act, okay? But where it's ambiguous, Chevron counsels that the agency can act. Now, look, there are people, and I'm not sure the FCC, I know that when I was at the FCC and we adopted the Open Internet Order, we didn't act in order to force Congress's hand. Now, I would like Congress to act, but we acted because we believed that broadband needed to have some oversight and that consumers needed to be protected and competition needed to be promoted. So I may...
Then why urge swift congressional action if Congress need not act?
Because we've gone through this ping-pong game now for 20 years where you have a Democrat in office saying Title II or authority, and you have a Republican, and then a Republican comes along and says, no, deregulate. I mean, this is not good for anybody. It's not good for consumers. It's not good for industry. So, yeah, I'd like to see Congress resolve the question.
All right, let's talk about another quote. This is from you. Quote, "While it's usually preferable that Congress be explicit in its statutory direction, there likely will be instances where an agency must rely on its expertise to interpret the intent of Congress." Now, you've just stated, and you and I both agree, that Congress is the lawmaking body, and that an agency should exercise only that rulemaking power delegated by Congress. So how does an agency's expertise interpret the intent of Congress? And is the intent of Congress actually what's at play, or is it the meaning of the statutory text, the original public meaning of the words? I think you can see my concern. My concern here is that to the extent we have federal regulatory agencies charged with administering a particular federal statutory regime, it gives them some regulatory enforcement authority. To the extent that that the people operating that agency have ambitions and policy views that extend beyond what Congress has utilized, especially with Chevron. Chevron is now being used almost as a sword, not just as a shield, to penetrate the will of Congress and to force Congress's hand to act where Congress has declined to act. Isn't that a problem?
Yeah, let me make 2 points. Is number one, again, and I think it bears repeating many, many times, I would love to see Congress act to give the FCC appropriate authority over broadband. Congress has not acted. However,
but where
the
in the
D.C.
Constitution
Circuit,
does it tell you that you've got the power to act simply because Congress doesn't act consistent with your liking?
well, the D.C. Circuit has said, both in the Mozilla case and the Verizon case, that the FCC has authority to bring broadband under Title II and to adopt net neutrality rules. So the courts have actually spoken. Look, as I said before, I've lived by Chevron and died by Chevron. It's an imperfect doctrine, but it is the law of the land.
Thank you, Senator Lee. That concludes